let's talk about this further and keep unpacking it. Joining us now live is Ronald Chapman, federal defense attorney and author of Fight the Feds, Unraveling Federal Investigations. Ronald, thanks for joining us this morning. Just a stunning turn of events last night in the 2024 race. This is the first time the insurrection clause has been used to actually disqualify a presidential candidate. Similar efforts failed earlier this year in Michigan, Minnesota. What makes the case in Colorado different?
Well, the only thing that really makes the case in Colorado different is the fact that Colorado decided to have a 5-day trial. And during that 5-day trial, they decided the essential facts of insurrection and determined that Donald Trump was the cause of insurrection. As you just heard from Chris Christie, no court should really make that determination unless there is a prosecution of Donald Trump and a conviction, or by potential impeachment. But Colorado did something different than the other courts, and they decided to have their own trial and make that determination, which did make the case ripe for Supreme Court review. I expect this case will get fast-tracked to the Supreme Court.
And speaking of, just the specifics of this case, as I was looking into it, I found it really surprising that this was filed in a district court in Denver by 6 voters. What was surprising, it was 4 Republicans and 2 independents, not a Democrat in that group. They sued with the help of a watchdog group. They argued that having Trump's name on the ballot would siphon support from their preferred candidates. What did you make of it that there was not a Democrat in that group who originally filed back in September? And do you think their argument held more weight because of that?
Well, I think that's what they say, that they're a group of Republicans and independent voters, but who really knows? I mean, they are backing this lawsuit. I think the really interesting thing about this is the case was originally removed to federal court, just like most of these types of cases, but then it was later kicked back down because the Secretary of State in Colorado did not want to join the removal, and that's why it filtered through the state court. So the fact that it's from Republicans may arguably give it a little bit more standing because it's not from Democrats, but I don't think that really goes too far with the Supreme Court when they eventually hear the case.
Looking into your crystal ball, and as we move forward here, because I know a lot of Americans waking up with a lot of questions this morning, of course, as we just heard in our previous reports from our correspondents on the ground, the Trump campaign vowed a swift appeal to this decision. The High Court is holding their ruling pending that appeal. What are the odds the Supreme Court upholds Colorado's decision, and where does this head from here?
And this is a very interesting question. First, Justice Gorsuch is the 10th Circuit justice, so he's going to have a first crack at this and be able to determine on his own whether or not a stay should be extended past January 4th. The only thing Gorsuch would need to do if he wants to is extend the stay further out than the ballot printing deadline or the primary deadline, and then this case is moot, meaning it can't really be decided. Or Justice Gorsuch could kick it to the total court and look for 5 votes to continue the stay here and resolve the question of whether or not he should be on the actual election ballot after full briefing and argument. And I expect that's what the Supreme Court will do. Wait for full briefing and argument on the myriad of issues we have and make a
decision from there. Sorry, we lost you for a brief second there. Yeah, I know a lot of people also thinking this raises the question, what kind of precedent does this set if this, in fact, is ruled and moves forward from here and he is off that ballot for 2024. Ronald Chapman, thank you so much for joining us this morning. We appreciate your time.